Berg says that almost all the courts of appeals have decided this question against you, and the leading commentators take the opposite position. How do you account for that?
So I think that's correct. I think these courts were writing, either now or at the time in a way that they were comfortable not following the literal text. Some of them acknowledge that they're not following the literal text, and this is just not consistent with the court's modern approach. I will say that most of these courts, at least 5 of them in the dissent, trace back to this DC Circuit decision from 1962, Austin versus Smith, that just didn't even mention Rule 60C1. But since, the coming of Justice Scalia in 1986, the court has taken just a different approach to statutory interpretation. And we cite an example of, I think it's U.S. versus Brogan, where all the courts of appeals had ruled 1001 gives you a right to lie, and this court just said, we're going to overrule that. And I think just last term you ruled against a case I argued when all the courts had gone our way.
Well, speaking of last term and lost causes, what do you say about Hewitt and the